Florida Department of Revenue. Counsel, are you ready to proceed?
I am, Your Honor.
You may approach.
Thank you, sir.
Again, we will allocate 20 minutes per side for this oral argument. Would you like to reserve some time for rebuttal?
Yes, sir. I would like to reserve 5 minutes, if I may.
So noted, Madam Clerk. You may continue, counsel.
Thank you, Your Honor. May it please the court, my name is Lauren Levy. I'm counsel for the Orange County property appraiser, Amy Mercado. With me today at council table is Sidney Rodkey, who assisted in writing the briefs and in preparation of oral argument. And also have the pleasure of having Ms. Mercado here to observe the oral argument with us today. Your Honor, this is a property tax case, which tends to be a little different type of case that comes before the court. But it also involves a fairly unique issue involving property tax matters and review of Value Adjustment Board decisions. I want to talk a little bit about the Value Adjustment Board process, if I could, before I go into the merits of the arguments. The Value Adjustment Board is a quasi-judicial body formed within each county, and it will review assessment issues, exemption issues, agricultural classification issues, assessment caps. There is a allowance for a modest exchange of evidence. There's no discovery, there is no subpoena rights to compel certain documents to be produced or witnesses. Hearings are frequently scheduled for 15 to 30 minutes at the most. A taxpayer is entitled to be represented by an agent who is not required to be an attorney or an appraiser. And the property appraiser's office is typically there with just staff. In counties over 75,000 in population, the hearing is conducted by a special magistrate. For valuation issues, the special magistrate is an appraiser with certain credentials for either commercial property or residential property. Each Value Adjustment Board has a VAB attorney that provides advice to the special magistrates and to the VAB body as a whole. That VAB attorney cannot represent property appraisers, taxpayers, or other local government bodies throughout the state. So they tend to just focus on this one issue. The Department of Revenue by statute has been charged with the responsibility of providing training materials for Value Adjustment Board, special magistrates, and body members of the body. This comes down to a very modest due process, short, clean, it's cheap. There's only it can't be more than a $50 filing fee, review of your assessment. If either party is dissatisfied with how the Value Adjustment Board hearing went, they can file suit in circuit court. That is a de novo challenge in circuit court. So in other words, we're not talking about did the Value Adjustment Board do something right or wrong. We're simply back to whether the property at issue has been correctly assessed or whether it was correctly denied an exemption. There is one exception in our statutes that allows a property appraiser to obtain judicial review of whether the Value Adjustment Board is following the applicable law and administrative rules in its decisions. And that's what we have here today. In this case, that statutory mechanism requires the property appraiser to file an assertion with the Department of Revenue. The Department of Revenue, that calls it their probable cause review. And the property appraiser seeks to establish probable cause that
Counsel, I am so sorry to interrupt you, but we need to take a 5-minute recess.
Absolutely, Your Honor.
We stand in recess.
Thank you, sir.
All rise. All rise.
Please be seated. Apologize for the interruption. You may approach council. And you may continue, counsel.
Thank you very much, Your Honor. And I think we had left off where I had talked about you could, either the taxpayer or the property appraiser can file suit to challenge the VAB result, but it's a de novo challenge and it's not a review of the actual VAB decision itself. It's not an appeal of the VAB decision. There's one exception to that, that's in 194.036(1)(c), that allows a property appraiser, if they believe there's been a consistent and continuous violation of the law or administrative rules, may file an assertion with the Department of Revenue seeking permission to file suit against the Value Adjustment Board. Not against the taxpayer, but against the Value Adjustment Board. And in that circuit court case, the circuit court would review the actions of the Value Adjustment Board, decide whether they comported with the law or not, and then the property appraiser would be entitled to two remedies. One would be an injunction to preclude the VAB from conducting similar actions in the future, and it could also act to restore whatever reductions were made to the assessment roll by the Value Adjustment Board decision. That's what the Orange County property appraiser did in this case. They filed the assertion with the Department of Revenue seeking a determination that there was probable cause to proceed to file suit against the Orange County Value Adjustment Board because the Value Adjustment Board, in over 120 to 150 decisions in all, had issued decisions where the special magistrates were making a 15% reduction, referred to as a cost of sale reduction, from the market value of the property to reach the just value of the property. The facts in this case show that the VAB attorney had issued a memorandum to all special magistrates directing those special magistrates to make that 15% reduction, and that VAB attorney did so based on a Department of Revenue advisement letter that, although the attorney recognized was only guidance and was not mandatory, that he certainly felt like the department had used mandatory language in the advisory letter, and therefore the VAB attorney
Counsel,
did not.
I have a question for you about the procedure set out in 194.036(1). So there's three ways that the property appraiser can challenge VAB findings, and this is the third way. Now, looking at this statute, it says within if the department finds that a consistent and continuous violation has occurred, then the appraiser is entitled to go to court. Is there any statutory requirement of what happens if the department does not find that there's probable cause that a consistent and continuous violation has occurred? Or is that just simply not covered in the statute and we just shrug our shoulders and move forward?
And no, sir, that's what's happened here today, is the Department of Revenue has denied the assertion. And the last time I had this issue before this court was in the Sowell decision. I cite the Sowell decision on the merits in our briefs, but there was a writ of mandamus issued by this court in Sowell that said that the Department of Revenue's action would be considered final agency action and subject to review by this court. So that's why we're here today.
So that's your jurisdictional basis for this appeal, is this final agency action under 12068?
Yes, sir. Yes, sir. As this court found. And really we're here again because in the Sowell decision out of this court on the merits, it involved the same legal dispute and factual scenario. The special magistrates were making 15% cost of sale reductions in their work product to arrive at just value. We alleged that that violated the longstanding rule in Florida that fair market value and just value are legally synonymous terms. The Supreme Court has said that 14 different times
So, counsel,
over 50
it's your
years.
position that the Sowell opinion is binding precedent on this panel?
Well, certainly this court could this panel could disagree with another panel's decision in Sal, and you were on that panel, Your Honor. But, that would then put us in the bonk area. I would respectfully urge that this court would adhere to its decision in Sal and likewise find that there's probable cause in this case.
What do you see as the rule of law that Sal holds that we are required to follow?
Yes. Sal held that a property appraiser's assertion based on the fact that special magistrates were making 15% reductions. When you're looking at a value, you're going to do an income approach, a sales comparison approach, and/or a cost approach. You arrive at that would be called an indicator of value. The Department of Revenue would suggest that once you arrive at that indicator of value, you must then make a 15% reduction.
Let me interrupt you for a second.
Sure.
I know there's a lot of detail in the actual calculation made here, but I don't see any of that in the opinion, which is why I asked the question. What is the rule of law that this case has? Not what was the case about, can you give us some of the background, but what is the rule of law that you believe that we're required to follow from this case?
The rule of law would be that the property appraiser has established probable cause to initiate an action against the Value Adjustment Board when he alleges there is a consistent violation of the requirement that all assessments be at just value, fair market value, Your Honor.
So anytime an appraiser says that?
No, you would need, obviously you would need a factual
Sure.
predicate.
Okay. So there is something there beyond just,
Yes, sir.
just simply making the assertion.
Yes, sir. Absolutely. And I believe we've established that factual predicate. We included 150 some odd decisions. You read those decisions, all of them are very, very clear and plain. Many of the special magistrates comment that the Value Adjustment Board attorney instructed them to make a 15% reduction, and they were doing it in compliance with the Value Adjustment Board's instructions and the Department of Revenue's training. We believe, Your Honor, that violates the constitutional requirement that all assessments are to be at just value or fair market value. The department disagrees in their analysis of the law.
How would you characterize the department's duties under 184.036.1C? How would you characterize their duties?
Sure. The appellate courts that have looked at this have characterized it as a true probable cause determination. The second DCA has also described it as the department is to find whether there's good cause to proceed with the lawsuit. The Sowell decision said, given the strong disagreement as to whether the board's actions in this case violated the law and the complexities of these issues, we agree that the department erred in finding there was no probable cause. Your Honor, I tried to characterize it in our case that you have to have certainly have to have a factual basis for the allegations. This has to occur, and then you need to have a tenable legal argument that this violates the law or the administrative rules.
So it's your position that the Sowell case presents the same issue as this case?
Yes, sir. The exact same issue, the exact same disagreement. It's the exact same disagreement we've been having with the Department of Revenue for quite some time now, Your Honor. The department...
Counsel, if the department statutory rule under section 194.036.1C is merely gatekeeping, why does the statute require an investigation and a finding that a violation has occurred rather than simply requiring the department to assess the facial sufficiency of the assertion?
I understand that, Your Honor. I don't think the department can adjudicate the dispute because then it would be acting in a judicial function, and I don't see that tasking given to the department. It is to investigate
What is a violation has occurred? What is that task?
That tasking would be to, is there facts that support the fact that this is a continuous and violation as opposed to like a one-off? And then it should be looking at under that whether a violation would be found under case law that is out there governing property tax appeals and property tax matters. Where the department errs, Judge Neff, I believe, is it thinks that it should adjudicate this matter as if it were the judicial branch of government. It's not given those duties and responsibilities. It describes the review in its decision as probable cause review, and the First, Second, and Third District Courts of Appeal have all recognized this as being a probable cause type of review.
So
Your
they cite in some of their documents that they go by the Black's Law Dictionary definition for a civil law probable cause standard, which is a reasonable belief in the existence of facts on which a claim is based and in the legal validity of the claim itself. Do you agree or disagree that this definition of probable cause is the correct one for this particular review process?
I think it's close enough, Your Honor. That's for a civil tort action. Again, you know,
Well, where does this probable cause come
that?
from? Where does the probable cause language come from? It's not in the statute.
No, sir, it's not in the statute. It is in the longstanding body of case law that we have.
Well, then explain this to me. How is the second DCA in Sarasota County with its, in essence, probable cause language, or MECO's in its true probable cause language, and also its good cause language, so it is even, like, it's different there. How are these in any way faithful to the text of the statute and what the department's responsibilities are?
Because I think they recognize, again, Your Honor, that the department is an administrative agency. Its function in this statute is to preclude a property appraiser from, let's say, intimidating the local value adjustment board with repeated lawsuits, and that the Department of Revenue, under this statute, is not tasked with adjudicating the legal validity of the issue one way or the other.
Okay,
Your
so-
Honor, they're not a judicial branch. They can't function in that way. There's nothing under our Administrative Procedures Act that allow it.
Fair enough, but what specifically in the department's review crossed the line from an investigation, which they are instructed to do by statute, into an adjudication?
Because they said that their view of the law is that when the property appraiser makes this 15% adjustment in the mass appraisal process, that they have to do the same adjustment when the value of the property is being reviewed in circuit court or the value adjustment board. And basically, although they won't say it in their briefs, they have adopted the position that Florida no longer follows the rule that just value is legally synonymous with fair market value. In their opinion, just value is you find fair market value, you then take 15% off for this supposed cost of sale mechanism to reach just value.
But is it undisputed that property appraisers throughout Florida apply a 15% cost of sale adjustment to property values pursuant to section 193.0118?
I don't think that's in serious dispute. Some counties use a different number than 15%. They may use 10% depending on the type of property. But again, Your Honor, this is in mass appraisal, and the statute subsection 8 requires I should say subsection 1 and subsection 8 are the two sides to a willing buyer, willing seller proposition. Subsection 1 says the property appraiser is supposed to look at it from the purchaser's point of view. Subsection 8 says the property appraiser is supposed to look at it from the seller's point of view, excluding cost of sale and also excluding tangible personal property. A classic example would be if I sell my house, I am most likely to sell it with a refrigerator, a stove, an oven, maybe I'll leave the washer and dryer there. All of that is what's called household goods or tangible personal property. That's not real property that the property appraiser is supposed to value. And so therefore you should take that out. All of those things are done in the statistical measuring process for mass appraisal, for the department's review of the assessment role. But when we go to the value adjustment board under our burden of proof statute and we're in circuit court, the test is whether the assessment exceeds just value, which is fair market value, not fair market value
Yes,
less
counsel.
15%.
But what specific authority supports your argument that the VABs, unlike property appraisers, are precluded from making adjustments for cost of sale?
I'm sorry, Your Honor. Would you please repeat that question?
What specific authority supports your argument that the VABs, unlike property appraisers, are precluded from making adjustments for the cost of sale?
Because the issue in front of the value adjustment board is whether the assessment exceeds or represents just value. and just value is defined as fair market value, legally synonymous, the same term, not different. And the Department of Revenue, they won't say it in their brief, but their legal argument means that fair market value and just value are two different terms. And if I may, Your Honor, I'll reserve the rest of my...
Before you sit down, I want
Yes,
to
sir.
digress for a second. Is it your argument that the department may not take any position on the merits of an assertion in a probable cause determination?
That they should not be adjudicating the merits up or down. They should look at whether there's a tenable basis for the legal argument. If there was a single case they could point to that says this case has rejected the argument, it might be different, Your Honor, but you look at the combinations of things they put together, this issue, Your Honor, has not been resolved, and it's very difficult to resolve because any of the other Value Adjustment Board mechanisms that you would try to choose are de novo, and so what the Value Adjustment Board did and did not do is irrelevant in that case. Again, I would reserve the remainder of time, if I could, for a rebuttal.
Thank you, counsel. We will
Thank you.
extend your rebuttal time by 3 minutes. We will also extend counsel for the appellee's time by an additional 3 minutes.
Thank you, Your Honor.
May it please the court, Timothy Dennis with the Office of the Attorney General. With me today is Mr. Stephen Keller, Chief Legal Counsel for Property Tax Litigation at the Department of Revenue. I'd like to jump right into the probable cause issue first.
Before you get there, counsel.
Yes, sir.
Before you get there, there's been a lot of discussion concerning this court's opinion in Sowell. Why doesn't our Sowell opinion control the disposition in this case since it dealt with the same issue?
Well, I would say, first, there must be some interest in the court revisiting this issue. I felt like when the court granted OA, because this is not one of the courts that automatically grants oral argument when it's requested by the parties. So, two, Sowell did involve largely the same issue. I concede that. But the court's opinion in that case did not provide any sort of guidance for the Department of Revenue. It described an issue, and there were some differences in terminology. There were some factual distinctions, although at the heart it involved essentially the same issue. But the opinion said, well, look, there's a disagreement, strong disagreement of the parties, and the issues are complex, therefore there's probable cause. It doesn't provide any sort of guidance for the
Well, what
for
it
the
does
court.
say is that when the issue is complex and when there is disagreement,
I
that
mean,
the
that,
department is not prohibited to
That-
refuse to make a probable cause determination.
well,
Is
that
what it
can't be
says?
the test. I mean, and let's go back to the
is that
statute.
what
You
the
were
case
looking
said?
at the statute.
That is what the case says, though.
That is what the case said, and I would invite the court
So-
to recede from that
That was my
opinion.
next
I would please, please, I'm here to hopefully, convince you to do so. And that goes back, though, to the language of the statute, Your Honor, that you pointed
Well, I
out.
assume you would concede that we would have to go en banc if we were to recede from Sowell.
I know there's been some debate about that in the
Based on
opinions of
based
this
on the
court.
present case law.
And that may be the law of the case now. So if this court feels bound by the opinion in Sal, just on the basis of,
If it was a two-paragraph opinion, what would we be bound by?
good question, Your Honor. I mean, but if they do, then, write about it and write about the merits too and provide us with that opportunity
I
to
want
see
to ask you a
come on
question, because
review.
I started reviewing this, and I kept seeing probable cause this, probable cause that.
Sure.
I went to the statute, there's nothing about probable cause. What the plain language of the statute says is that the department is empowered to do three things: investigate, a fact-finding function, determine whether the asserted violations were consistent and continuous, and three, make an up or down finding as to whether these asserted violations were against the intent of the law or administrative rules. Is that what you're empowered to do under the statute?
Yes, it is, Your Honor.
Okay.
and
So
the-
is that statutory framework intended as a screen against frivolous or unfounded challenges, or is it something else? What is it?
No, that doesn't make sense, Your Honor, because any circuit court judge could, screen out a patently frivolous claim. No. Look, The statute provides for an decision, and, upon investigation, and that the continuous and violation of the intent or law or the rules has occurred. You've nailed it exactly right. The discussion about probable cause emanates from these two second DCA opinions from Sarasota County in the 1970s. What the court was describing in that case was the effect of the department's ruling if it found probable cause then. What the court was really focused on in those cases is they were saying, look, it's not a binding holding on the circuit court if it goes. It just means that the property appraiser has the opportunity to go to court.
But it is a gatekeeping function. If you find that there was a violation, a continuous violation, they're allowed to go forward. But if not, they're not allowed to go forward. Is that correct?
That's true. And under
So what's their remedy if they're not allowed?
Well, under Sal 1 in this case, where this court held that this is a agency final order under Chapter 120, and an agency final order has to include findings of fact and conclusions of law, the remedy is to come up here and say we did it wrong.
Counsel,
That's why we're here today.
Was Sal a two-paragraph opinion?
Your Honor, I think it was, I don't have the opinion in front of me. It was slightly longer than that, but essentially it described the issue. And then it said, but the essential holding didn't broach the merits as to whether the property appraiser or the department was correct or incorrect at the end of the day. And that may have been because of an unfortunate response to a question that actually Your Honor asked at that OA about what they should do if they remanded it to the agency. But it didn't address the merits at all.
Counsel, I got a couple of questions. First is, I can't help but notice that the title of the document that you produced says probable cause review, first of all.
Correct.
So it does appear that at least the department at least conceded when they did this document that they were making a probable cause review.
Well, probable cause review in the context of the definition that it provided in the notice of appeal, which is the Black's Law Dictionary that Judge Neff referenced, and that they included in their brief as one of the many several definitions. And that includes not only an evaluation of the facts, but an evaluation of the legal validity of the claim itself.
I've seen a lot of probable cause determinations in different contexts.
Sure.
Not a single one of them has ever looked anything like this. This looks way, way more like an agency final order than it does a probable cause review. So my question is, after reading 20 pages of detailed findings of fact and conclusions of law by the agency, what is left for the court? Are these binding on the court, or are they just your opinion?
Look,
assuming that you did say, sure, you can go to court on this, are these binding?
Well, of course, here we're saying that they're not, that you can't go to court, but if the department were to have reviewed an issue and said you can go to court, what the second DCA, MECOS and Property Appraisal Adjustment Board says, look, it's an adjudication, but it's a preliminary adjudication because the property appraiser still has a discretion of whether or not to sue the VAB and that he still has discretion and that it's not binding
Maybe I'm
upon the
misunderstanding.
circuit court.
You've taken away that discretion with this order.
Well, and that's why those cases were also, at least the first case was addressing where the department found probable cause, and it was the Property Appraisal Adjustment Board saying, hey, there's a problem here. So here in Sal 1, the court said, if you deny probable cause determination to the property appraiser, if you deny a determination to the property appraiser, they can come here.
Counsel, as a follow-up to Judge Reynolds' question, is it your position that Section 194.0361C allows the department to make a full determination on the merits of an assertion?
Well, I think it's certainly more than a gatekeeper function, and I think what the department here was evaluated the legal validity of the claim. So It's certainly more than a gatekeeper function. I think that's what the statute suggests. And again,
If you're following
if
the statute,
there-
the statute requires you to find that something has occurred. What does that mean?
correct.
What does that mean?
That means you have to find whether there's
It's not
a violation.
probably occurred, might have occurred, good
Right.
good
It
belief
doesn't
that it
say
occurred. It
if
says
there's
has
good
occurred.
cause that it occurred. No,
Okay.
no, sir. It says has occurred.
So is this a proceeding under Chapter 120? Is this a
You know, that's a
125-69?
great question. That doesn't, the court in Sal 1 did not answer that question as to whether the full panoply of, you know, Chapter 120 rights to an administrative hearing before DOA, you know, are available to contest this. And we haven't argued exhaustion of administrative remedies. They just said, look, if you do this, it's an agency final order subject to review under 12068. I really don't know what, you know, I mean, we're sort of getting out there, but what I can say is they can at least come here. And the statute does require more than just a gatekeeping function.
So in other words, it's your position again that the statute allows the department to make a full determination on the merits of an assertion.
Well, I think in a way you could say yes, because if they did and the property appraiser's unhappy with it or believes that the department's made some legal error, they can come up here and seek appellate review. And if the department finds that there is probable cause under MECOS and the Value Adjustment Board, it is a finding, but it is not res judicata. It has no precedential effect. The statute says if you go to the circuit court, the trial's de novo.
Isn't that further evidence to suggest that you can make a determination, but it's not binding on the court? Because
absolutely.
the last paragraph, or the last subsection here of
Right.
of the statute says the circuit court proceeding shall be de novo, and the burden of proof shall be upon the party initiating the action.
There you go. Now, again, turning to the merits of this case, I would like to talk about that a little bit. In its de novo, and the property appraiser just sued the taxpayers, they could still, you know, again, it's de novo there too, but if
So
they just.
explain to me, why would we address the substance of this case if it hasn't been to the circuit court first to do the initial de novo review?
Well, here, because the department, well, I think you would have, I mean, I think there could be, if you were to find that the department had, I'm sorry, can you please repeat the question,
Yes,
Your
my
Honor?
question for you is, why would we, at this procedural posture, where there hasn't been a circuit court determination yet, right?
Right.
Why would we address the substance of the issue at this point where there hasn't been a circuit court determination first, which according to the statute gets de novo review of your position, then goes to circuit, then comes here? Why
Well,
would we address the substance?
No, because if the department finds, you would have to find that the property appraiser could still go to circuit court based upon, and I think the intent of the statute is if the department says there's no probable cause, the property appraiser can't go to circuit court, so they're coming up here to ask for review of the merits of the department's legal determination. There may be some aspects of that need to be handled at circuit court, but if this court were to decide, hey, no, we think there is, you know,
But
an
is there
error
only
here, a
function here
legal error
whether or
by
not the gatekeeper function that you are empowered to do by statute? It's kind of a gatekeeper function.
Yes.
Because it's you
That's so the
gatekeep getting into the circuit court, right?
The legislature wrote the law, right. And I think that's important to know why. You know, because, one, the department has general supervision authority by law over the whole process. Now, you know, it's in relation to individual constitutional officers. The Value Adjustment Board are elected officials. But the department has general supervisory authority over the whole deal. And it results in government funds being used to sue another governmental entity. So there's important policy reason why the legislature might have considered giving the department this function. But two, it ends up, if the property appraiser were to go and prevail or reach some settlement with the VAB where they say, okay, well, we'll capitulate, we'll restore the roll. The taxpayer is then put in the position of having to come back, in this case, years later, to possibly have to contest their tax assessment a second time. I mean, the statute has that stopgap. So I think there's important policy reasons why the department has that function. It's just minor, it sounds like the court's very interested in that issue, but just if the court decides to address the merits, I just want to point out the key to understanding this is the relationship between the Constitution and Section 193.11, specifically 193.11.8. Article 7, Section 1A, no tax shall be levied except in pursuance of law. Article 7, Section 4A, by general law, regulations shall be prescribed, which shall secure a just valuation. The legislature has enacted Section 193.011.8 that requires consideration of the cost of sale, and it's been the law since 1967. It requires application to both the sold parcel or any other parcel. It's in the statute. And there isn't a dispute, as Mr. Levy indicated. Property appraisers nearly universally do this by applying an across-the-board adjustment when arriving at their just values for purposes of the roll. The department's view is saying, look, to get an apples-to-apples comparison, if the property appraiser is going to do that, and it has become a professionally accepted appraisal practice because it's in compliance with the law and has been in place for many years, then the Value Adjustment Board, when they reach an indicated value, in order to have a true apples-to-apples comparison, you have to perform the same thing. You have to perform the same adjustment equal to what the property appraiser did. That doesn't convert the Value Adjustment Board into a board of adjustment, because a board of equalization, because they're not statistically measuring, like the values that are derived, the end results. They're just saying the methodology has to be fair. What's good for the goose is good for the gander. Walter V. Schuler, that's hard, right? It says fair market value, just value. Decided in 1965, pre the 1967 enactment of 193.11.8, prior to the enactment of the 1968 Constitution that contains these articles. We've pointed, now the court 20 years ago at this point said it, Supreme Court said it the last time, but they've never been directly addressed with this issue of this cost of sale adjustment. Many other courts that we've cited to in our briefs, when they have been confronted with this evidence of a cost of sale adjustment, particularly, I would point to the 1995 decision from the 4th DCA at Southern Bell. They described that exact approach: reach a value, take an adjustment for the cost of sale, and they said, we see no impropriety in this approach. This is workable. The department is simply trying to harmonize the case law, the Constitution, and the statute to create a level playing field for taxpayers who seek review.
I'm sorry, Counselor, I'm still hung up on this probable cause thing.
Sure.
So I guess I'm curious, how do your staff do this review when the courts have been all over the place? They don't even know what the standard is. They've said, in essence, probable cause. Then they say true probable cause. Then in the same opinion, they say good cause. Are there any rules that have been developed to give both your staff and the people on the other side guidance into what you are doing or how to do your job? Like, how does this work?
Your Honor, I have to say, sorry, I do not know if there are any specific rules in the administrative code.
Which probable cause standard are you using? Because when I
related to-
looked at them, there's like 7 or 8 across criminal, civil, and administrative.
Right, that's why the department relies on a very simple definition, the civil probable cause standard. Look, if this court wants to recede from, wants to disagree with the second, I mean, I don't think that requires en banc interview and say, look, this ain't probable cause. We're okay with that. I mean, but, I think what they do is they look at the assertion. They're required to get the records of the appeal. Now, the property appraiser says, well, that's all you can look at. All you can look at are the records on the appeal, but I don't think that's correct. That's not what an investigation is. And then they look at the evidence, and they look at the law, and they make a determination.
So, counsel, if we are, just to follow up once again with Judge Neff, if you've adopted the Black's Law Dictionary definition of probable cause in the civil context, it's whether there is a reasonable belief of the existence of facts on which a claim could be based. So they have a belief. I guess your goal then would be determine whether that belief is reasonable.
Well, I don't think it's a reasonable belief in the facts. I think you have to look at the second part of the definition, and that is belief in the legal validity of the claim itself.
So are you, again, that you're right. Are you saying that it was what they are asserting, what the property appraiser is asserting is unreasonable? And that's the standard that you've used in this to say that they are not permitted to go to court because their claim is unreasonable.
They didn't characterize it like that in the probable cause review, but I'm thinking that if it is not in compliance with the established practice of the past 40 years of the property appraisers and ignores Section 193.11.8, I think that would be unreasonable. So, Your Honors, hearing no further questions, I think this.
How do you respond to this court statement in Sowell that given the party's strong disagreement as to whether the board's actions in this case violate the law and the complexities of the case involved, we agree with the appellant that the department erred in determining that there was no probable cause of a violation of law?
I'm sorry, I don't understand the question.
I repeat the statement again from the court. And how do you respond to the statement from the court in Sowell? This is a statement directly from the court. Given, and I think counsel for the appellant noted this as well, given the party's strong disagreement as to whether the board's actions in this case violated the law and the complexities of the issues involved, we agree with the appellant that the department erred in determining there was no probable cause of a violation of the law.
Well, I think you could say two things. One, that an opinion like that provides it's extremely specific to this one issue and doesn't provide any guidance to the court or its views on how we're supposed to handle these things generally. I mean, and that's, if the court disagrees that the department is wrong, in its evaluation on the legal merits, then that would probably be preferable.
In other words, the department wants some guidance from the court. Is that your point?
Guidance, I mean, there's no, I mean, look, there's always going to be there could well be strong disagreement. I mean, how do you measure strong disagreement? How do you measure complexity of the issues? I guess that would be the question that, we're left with, And look, to the extent that this case addressed the same thing, I'm clearly asking this court to write about it. If you would have decided the case differently, write about it and let us seek en banc review.
One other question before you sit down, counsel. how does the amendment to section 194.301 and the creation of section 194.3015 have any effect on the rule of law that market value and just value are synonymous?
Well, it doesn't directly do that, but what it does say is that the value adjustment boards now have to, if the evidence is there, that comes up with, complies with the statute and with professionally accepted appraisal practices, that they are to make that determination themselves in the circuit courts in the case of a circuit court challenge. You're not simply just to remand back to the property appraiser and say, do it again.
But don't both only address the burden of proof in assessment challenges?
I don't think so. I think it addresses the burden of proof, but I think if you read those two sections in Parameterian, that it is clear that the value adjustment board is supposed to look at the methodology of the property appraiser too, and if they determine that that's appropriate, how can it be then inappropriate to use it for the taxpayer against their numbers?
Thank you, Counsel.
Thank you so much for your time, Your Honors. We respectfully ask that you affirm.
Your Honor, if I may start with the question you asked last, how does a change to the burden of proof statute change the longstanding rule that fair market value and just value are legally synonymous terms? It would be our position that it hasn't changed that, and there's been no court decision that has said it's changed that. We only have 2 appellate court decisions issued since the burden of proof statute was changed. That's the Darden case versus Singh and the Disney case versus Singh, both Orange County cases. In both of those decisions, the 5th DCA said just value and fair market value are the same term. So the appellate courts have said we have a change to the burden of proof, but just value and fair market value are the same term, remain the same term. The Department of Revenue participated in those appellate court decisions, Your Honor. So we don't believe there's been any change, and we believe that the appropriate thing the department should have done in this case, even though it may disagree with Sal, would be to say, we find probable cause exists based on the First District Court of Appeals decision in Sal, and let the property appraiser move forward and argue the merits of this dispute with the body that it has the dispute with. The dispute is with the Orange County Value Adjustment Board. Counsel mentioned that the Department of Revenue has general supervision, and they have done Value Adjustment Board training materials that has some of this 15% stuff in them. The property appraisers challenged that in a rule challenge and said that has to be done through rulemaking, because the state agencies only officially speak through rulemaking. The DOA judge, the Department of Revenue, said, well, what we put out in training is not binding on value adjustment boards or special magistrates. It's simply our opinion on the issues, and value adjustment board attorneys need to advise their own value adjustment boards. That was affirmed by this court, PCA. So with that in mind, the dispute is between the Orange County Property Appraiser and the Orange County Value Adjustment Board that over 150 decisions removed $250 million worth of assessment off the tax rolls. That is a real and substantial disagreement, and that disagreement, we would respectfully submit, should be allowed to move forward in circuit court with a proper record developed, with proper arguments made, a decision issued by the circuit court, and then the 6th District Court of Appeal would then be in the position to review that decision if an appeal were sought. So we would very respectfully ask this court to continue to adhere to its Sowell decision. If you decide that the statute requires something other than probable cause, then we would have to look at the merits of that issue. The department's own administrative rule defines just value as that arm's length transaction, willing buyer, willing seller. That is fair market value, and taking 15% off of fair market value does not equal just value. Those two terms have to be the same. So we would ask that you reverse the department and allow this matter to proceed in circuit court. Thank you very much.
Thank you, counsel. This concludes our oral arguments for this afternoon. We are adjourned.
All rise.